stuck in bad investment, how to navigate Indian promoters and courts for smooth exits. Matt Nimitz, he is Advisory Director of General Atlantic LLC. Vyapak Desai is partner in charge of international litigation and dispute resolution practice. And Weber Parikh, partner private equity and M&A. This is a very interesting session, and I think it would be useful to have. Let's start, I think, oh, sorry. Oh, Rajesh. Oh, Rajesh. Okay, welcome. Sorry, you all know him by the time, you know. Come. So, because time is short, Matt, I think we should start with you. What are the challenges you've seen while planning an exit for investment in India, you know?
Well, we'll talk about the promoter. Let's talk about the promoter. We'll talk about the promoter also. I think the big issues on exits in India, and Chris mentioned them. One is in the U.S. we have two types of exits. One is IPO exit. The second is strategic acquisition. And the General Atlantic, if you look at our 34 years of history, probably half of our exits have been strategic sales and half through public market sales after IPOs. Not in the IPO necessarily, but after the IPO. When you look at India, strategic sales are very, very difficult. First, you don't have a lot of foreign companies coming into India, buying up companies there. And you don't have the same tradition in India of takeovers. So you don't have a lot of opportunities to and then we occasionally did. We've done a few of those, but it's much harder. And then mergers of equals is very difficult. We'll talk about the promoter system in a minute, but so the main method of an exit is public sales of the stock, doing an IPO, and therefore you're up against the vagaries of the public market, which obviously in the last few years has been very difficult. And if you have a big block of stock in a company, the public market is not an easy place to unload the shares. So you sometimes can sell a large block to another private equity firm, something like that, or other types of interesting strategic methods. But I think the exits. That said, we've in the last we've been making investments in India for 12 years, 13 years, and we've had a lot of exits, and we've had successful exits, and we've gotten our funds out, and we've been very happy with the exits. But it's a harder process. I will say, you know, since this topic here is about promoters, the promoter system in India has an effect on the exits, because the promoter it's not just the founder. The promoter is often an individual who has other interests and other aspirations, and it's not necessarily 100% in this company. He or she may be the CEO, but may not be. May just be the chair and have a CEO who runs it and then has other interests. And what we found was many promoters have not a total alignment of interest with a private equity investor. That is, they're not necessarily interested in a public offering or a sale of the company. They have long-term strategic interests in the company. Maybe because they're interested in other companies in the area. Maybe they get a certain prestige out of it. Maybe, I think Chris mentioned dynastic interest. That is, they want their children or nephew grandchildren to play a role in the company. The Western view that all shareholders are interested in maximizing value is not necessarily always hold true in India, especially with the promoter class.
Thank you. Weber, I think what should be the pre-litigation strategy,
Yeah.
if you can talk a little about that.
So we always say, how do we first try to prevent a dispute? And secondly, if you can't prevent a dispute, how best prepare for a dispute? So I look at it, pre-litigation strategy in two ways. First thing starts with diligence. When you're making an investment, we have found that about 70% of the disputes could have been indicated at the diligence time. So either you would have known it was there in diligence report, or it should have been there in diligence report. Often that signals are being missed, and when you miss the signals, you give a greater probability of disputes happening. So get your diligence done correctly. And diligence is not just diligence from company perspective, not just legal and financial diligence, but diligence of promoter. I have a client which says that I will only invest in a company where the ethics of a promoter is very good. And what do you mean by that? The promoter is very conscious about his reputation. Reputation conscious promoter, reputation conscious management is very critical in their mind when they invest. Secondly, about promoters. We like, when we invest, we like to invest in a promoter who is connected, So, we say, I'm investing in a company, this promoter is very connected, things are going to go very well, very fast, but the same connected promoter becomes a big liability whenever there's a dispute. And so that's the other issue we need to be very careful about. Doing diligence both at the corporate level and at the promoter level is very important. That's where your strategy, pre-litigation strategy starts. Second is, once you sign the agreement, often what we do is we set up and put in a lockbox. We don't even look at it until the dispute comes. We have found in some cases that some of the rights you had in your agreement, you never implemented. Implementation of an agreement becomes very, very critical. I'll just give an example. We had a client where they had a right to appoint a director, basic stuff, or appoint certain rights in the articles of the company, in the corporate charter documents of the company, because certain rights in a charter documents are very, very crucial if you want to enforce your rights. They were not there, and they never looked at it, whether they were actually put in the charter documents of the company or not. So implementation of your agreement becomes very critical. Other thing which we do at our law firm, which we advise, is that, transaction counsels are very different than litigation counsels. And often transaction counsels work on ideal scenarios. They don't work from dispute perspective. We run our agreements through litigation team because we today want to prepare, if this document gets disputed, what are the holes a promoter will find or other party will find. So you really want to look at it before making investment rather than later making investment. Other few experiences which comes from my own personal places, if you really see where disputes happen, one, disputes happen on related party transactions. Second, disputes happen when, on the financial mismanagement, there was an example where a company or a promoter cooked up the books from inventory perspective. They said, I have so many inventory when he did not really have an inventory. Third, disputes happen on compliance perspective. No major compliance is done. He has paid money, bribery, corruption, etc., etc. Now, if you really look at those situations, I find, and Chris mentioned during the previous session, your key rights, you should focus on getting your CFO. Forget everything else. You should have a right to appoint a CFO, or at least whoever is a CFO, you should have a right to remove or veto or whatever rights you get. And the second important person, other than CFO, is company secretary, or what you call secretary here in this state. The reason is, lot of filings, corporate document filings are done by the company secretary in India. And lot of times frauds happen because, and during the disputes, all those filings which give you right, and I'll give a live example. Our client had made an investment in a company, and he got minutes done where his nominee was appointed a director. And when disputes came in, there were no such minutes there for directors. Form which was supposed to be filed with the MCA, which is the Indian government, to say that this person is a director was missing. And as a result, he did not get right to vote as a director, which was a very crucial right which he would have needed. So company secretaries become very crucial, so have a right to appoint a company secretary. Third point, when you sense a potential dispute, I think that is the first time you should run to a lawyer. Don't wait for dispute to really start, but you feel that there is a potential, run it through lawyer, because you want to what Vyapak calls sanitize all your correspondence. You don't want to give up rights in an email saying that, maybe I will, I have a right to have a put option, but I will give it up. You don't want directly or indirectly by your action or by inaction give that indication, because promoter will pick that indication up and use it against you in litigation. So make sure that any correspondence you do is run by a lawyer or a counsel, even before the litigation is started, even before your bridges are burned, even before there is a situation where you got a issue notice. You have to prepare your case. You have to prepare your evidence, and for that you need to come very, very early. I think that is what our experience suggests. Get all your filings and all your communications done in a way that if at all it goes for a dispute, and hopefully it won't, but if at all goes for a dispute, you have a very strong case. So preparing for dispute is a very important pre-litigation strategy, according to me. Thank you.
Thank you, Vaibhav. But I think, Vyapak, I think you've been involved in, he's a litigator, so you can really tell what your real life experience is and give some ideas about what kind of issues lead to dispute with the promoters.
Sure.
So
when it comes to experiences, I think, as Nishith said, we believe in incarnation, so we live with the dispute, we die, and then come back. So it's only horror stories, right? You can't get a better story when you have that kind of an, way to do or settle your disputes. But having said that, I think things have changed. There is a lot of emphasis on faster delivery of justice. Arbitration has become a huge potential way of dealing with these cases so far as India is concerned. The law on arbitration is very well based on the unicitral model, equivalent to any other jurisdiction where you find those laws. And if you rightly word some of those provisions, I think there is a way to tackle and get the settlement done or your disputes settled in a more objective way, rather than just in the form of enforcing your rights under the agreements. Having said that, I think broadly we have seen three categories of disputes when it comes to private equity. The first and the foremost which we have seen is in the form of, let's say, misrepresentation and fraud at the time when you invest. So there are several pages and several issues where promoters or the existing shareholders would have represented based on which you have invested. And then over a period of time, you come to know that, okay, this is not something which is accurate, or this is intentionally made inaccurate. So that is one big category of disputes that we have seen when it comes to private equity disputes. Second big one is obviously breach of obligations. Again, in India, people take things very lightly when it comes to obligations. So you need to be very, very careful because what you write doesn't mean that what you meant. So I think breach of obligations are one big category of disputes which lead to exit situations. And the third, the most important one, which I guess we have discussed through the three panels today, is more on the issue of governance, which is siphoning of funds, related party transactions, cooking up books, and basically things which relate to the financial management of the company, which ultimately leads to a situation where you don't get the value which you expected at the time you invest. Now, when it comes to India, again, it's a little complicated because not every such breach or every such misrepresentation or every such mismanagement leads to a common set of dispute resolution mechanism or common set of law which applies for a better exit route. Also, as we discussed, civil turns into criminal very easily. So the moment you say there was a misrepresentation leading to a fraud, you will find a lot of issues even in enforcing your rights under dispute resolution when it comes to civil or any arbitration modality that you might have fixed up in your agreement. So I think what is important is you knowing your objective as to what you want to do with this company. Sometimes you are looking at taking over the company or the control so that you can ultimately seek value and exit. Sometimes you want to exit at that very point, or you want to possibly sometimes only look at the breach and see whether you want to recover the damage or the valuation which you have lost over a period of time. So I think what happens, unfortunately, when it comes to an Indian scenario is the kind of dispute resolution mechanisms and the laws are, it is very difficult to choose where you fall in or which category you fall in, and you don't choose your right remedy so far as the dispute resolution is concerned. So I guess depending upon which category of dispute you are in, you need to be very, very careful on what kind of dispute resolution or a litigation strategy you choose as to which category you fall in, right? Whether it is fraud, misrepresentation, material breach of obligation, or it's a case of mismanagement.
Thank you, thank you. Matt, I want to just come back to you. What challenges an investor director faces while the fund is in a dispute with the promoter? You want to take that?
Well, before I answer that question, I want to say something positive about promoters.
Sure.
Because we talked about India is a promoter-based economy, at least in the areas that we invest, or most of us invest. And a promoter in India is sometimes we call them a founder, but we don't have an equivalent here. It's not just the founder of a company, it's a serial founder who dominates the company, doesn't necessarily stay full-time, moves assets around to different companies, makes sure the company's successful, knows everyone in the government, is well connected with suppliers and with banks, and you know, we've made 12, 13, 14 investments in India, not all with promoters, but most with promoters. And the way you make money in India is to work with a good promoter. So we're talking here all about the disputes with promoters, but I will say that the most important point has been made. That is, you need due diligence on the promoter. I say three things. One, due diligence on the promoter, and the mistakes we've made in that connection, when we've made mistakes, is not taking some warning signs seriously, you know, saying, oh yeah, we've heard some things, but we can live with it. So to really do due diligence. But secondly, alignment of interests. To make sure that your interests are the same as as the promoter, and that takes a lot of conversation because we're talking about exit strategy, we're talking about growth strategy, we're talking about management, and the promoter has different interests, and of course they'll say the right things, so you have to really probe. But for example, management, very often private equity people like us, we come in and we say, well, we ought to change the CFO. We just talked about strengthening the CFO. But the CFO is often a nephew or a cousin or a relationship with the promoter. He's there because the promoter trusts him and because he gives the promoter the numbers first. He doesn't give it to the board first. He gives it to the promoter first. And the promoter doesn't really want to change the CFO. And he has other people in the company who are connected with him. So getting some understanding about management, getting understanding about growth strategy, getting understanding about exits, really need a lot of discussion. I think that's very important. It's not just whether the guy is fraudulent or not fraudulent, or a bad guy or a good guy. The most promoters are in the gray area of being pretty savvy guys who occasionally do something in the gray area, but you've got to be aligned with them. And the last thing I'd say, you have to spend a lot of time with the promoter after you make the investment. You've got to have dinner, you have to talk, you've got to get to know them, you have to go to family weddings. The relationship is not just a relationship of making the investment, it's an investment in a long-term relationship with the guy who's really running the company. And I think the big mistake of private equity people, especially we Americans, is we think everything is rational. And so we go in and we come up with some good conclusions about how the company ought to work, and we explain it at the board, and everyone nods, and then we leave and we find that nothing's implemented and no one's actually agreed with us, really, but they're very, very polite until we leave. And we get very confused because we obviously are very rational in our analysis of the company, but the promoter, he has other ideas. So the board is not necessarily the place where the real serious discussions take place. You have to have the private discussions and sit down with people privately and work these things out. The question you asked is what we do when we get ready for a dispute. We've had disputes, we've had litigation, we are involved in litigation, and I do think avoiding litigation is really a great art, and it should be pursued. That is that it's better to get a somewhat reasonable settlement without litigation than go through litigation and hoping for the best, but probably get not much different from what you could have gotten beforehand after a long period of time. So we can talk about that later. I would say that attempts to reach agreements before one goes to litigation, assuming that it's not outright fraud or something that's so dramatic that it can't be resolved. But where there are disputes, the promoter will always hold most of the cards. This is something that I believe, and I believe it with equivalent in China and equivalent in Brazil, and basically equivalent for New Yorkers in Texas or in Kentucky. That is, when you're in a different culture and geography with local people who view you as an outsider, even if you're right, you have to recognize that you're not in there for the very long term. You don't know all the ins and outs. You don't have the patience that the other people have. You're not going to be there for the next 20 years the way that all of them are. And you don't have the long-term relationships that all of them have. Therefore, as outside investor, it's much better to work things out than to go to litigation. Nevertheless,
Yeah.
sometimes you have to do that. And then the first thing is to get very good lawyers and take their advice, right?
But I'm very sure that GA Partners is going to have a very great future because you've got whole full life cycle experience, I think. So you can build on that and know what not to do in India, what to do in India, and how exactly it is, not only in terms of civil law or other criminal side as well, all the kind of things that you talk about. You've seen it all. So it's a great investment that has been made. I know it's quite stressful sometimes, but I'm sure in next 5-10 years, you will have a lot more edge compared to many other ones because you know exactly how things work in India. And I think that was a very helpful, commentary on your experience. And but Vyapak, if when default is committed by a promoter, what are the remedies? Can you
Sure.
just quickly say in next about 10 minutes we'll be winding up, but
Sure.
I would.
So I think what has happened if this question would have come, let's say, a couple of years back or 2-3 years back, I think there was very little to talk about because one, the litigation system in India was not able to, give any support to any kind of such remedies. When it came to arbitrations, I think two sets of people, the existing judges and the retired judges, because of the ad hoc way in which the arbitration worked, did allow the arbitration system to function or the objectives to meet so far as arbitration was concerned. But what has happened over a period of last couple of years is there is a lot of emphasis laid on speedy disposal, particularly when it comes to arbitration, non-interference of judiciary or court system. And it all started with one judgment which we famously called the Balco judgment, where everything was now seat-centric. So the moment you choose a seat which is outside India, you are able to deal with your dispute much better without any interference from the Indian court system, which means you are basically eliminating the 10, 20, 30 or whatever lifetime you invest in a litigation in India, completely taking it or outsourcing it to a seat which you have chosen which is outside India. So I think when it comes to a dispute, what is important is to think through when you are investing in India as to what kind of dispute resolution mechanism you are choosing, what kind of seat, what kind of arbitration clause you are choosing, because that would depend a lot in your litigation strategy when it comes to a dispute with the portfolio company. Interestingly, we have seen quite a few cases in the past where we tried, different mechanisms to see if we find a good settlement or a good exit. One of the ways is it is very typical for an Indian promoter to agree to a kind of exit, let's say put option, and then say after 3 years that, okay, this is illegal in India and not enforceable. What happens in the process, a lot of people have a very narrow mind on this kind of a issue, and they are like, okay, this is my right, I'm going to enforce, you have to give me the shares. I think what we tried in one of the cases is to go back and tell to the promoter that, okay, if this is illegal, we agree with you. Which means what? The contract is illegal, so put us in the position back, which means give our investment back with the interest or whatever is lost in the process. The moment that kind of a plea was raised before the arbitration, there was no defense for them to say, because they agreed that yes, we have taken the money, but we can't give it back because regulators don't allow us to give back. And they had no defense to the counter rather than enforce the right of a put option. And obviously they had to settle because otherwise they had to return the money much faster than what we would have agreed under the settlement, because we wanted to avoid the enforcement issues in India. In another case, rather than going to India, we tried taking freezing orders for the assets that they have created outside India. So again, that worked wonderfully because they had mansions, they had assets, they had houses, they had businesses outside India. And we tried to freeze some of those assets outside India rather than litigate in India. The moment we could even start that litigation, I think the threat of freezing or the threat of putting their assets outside India under a risk was good enough to get a litigation. So I think the short point on India-driven litigation is to see how you don't litigate in India rather than litigate in India. Doesn't mean that you don't use the Indian litigation system, but there is enough that you can strategize it well to ensure that promoters or the disputing party comes to a settlement negotiation much earlier than what you want to do. And there are various other methods or various other issues which you can adopt. As I was saying, one way to look at is, look, I invested, I have come up to this level now, I need my internal return, what you promised, and therefore I need to reach to a particular destination. And the other way is to say that, look, whatever way we have come halfway, let's go back and call it quits. There is no way under Indian law you will not get that kind of a remedy, because law and Contract Act does not allow somebody to benefit out of a contract whether it is illegal or otherwise. There were a lot of issues in enforcing certain misrepresentation leading to frauds, because then you have to rather to go to a criminal court than a civil court for adjudication of disputes, which again there are judgments now in the recent times which allow you to litigate in a civil nature or a civil dispute rather than in a criminal way, and therefore enforce your rights under that fashion as well. Also, what Nishith was pointing out in the last session, I think even the courts have realized that the Indian entities or the promoters may be using or misusing the criminal way of dealing with the issues around getting arrests done or the possibility of the arrest done. And recently Supreme Court came very, very heavily on some of those methods and some of those issues which have come up during the last couple of years, and have actually laid down principles before a police authority would take up or take cognizance of any of those cases. So I think all in all, I would say in last couple of years things have gone from worse to positive. Now I don't think we can go any further down south. It's only looking up, looking positive, and possibly if you really focus on an objective-based litigation strategy versus a rights-based, which is just looking at the contract and keeping on enforcing it, I think we have seen quite a bit of litigation strategies working compared to what it was a couple of years back.
I think that's a good thing, because you have to change your attitude in India towards litigation. So one of the most important areas of litigation in India has been tax, and I think tax has the last word, looks like. So Rajesh, maybe you want to say something about what are the potential areas in a transaction that may lead to tax litigation. And finally, I think, Vyapak, you tell about enforceability. I think with those questions, and then we'll take, there are quite a few people still on the phone, surprisingly, and we'll check if they have any questions. So I just got a request.
So let me put it this way. You can get out of the Indian courts, you can get out from the clutches of the Indian promoters, but not really from the tax authorities. But today, when you look at least the tax litigation, from what I've seen on the private equity investment, I've seen three broad areas where disputes have arisen. These are both disputes vis-a-vis the investee companies and also sometimes vis-a-vis the tax authorities. I think the first area is really on the reps and warranties in terms of the kind of reps that you've got from the company. When you've done the investment, there's a whole bunch of, you probably have a 2-page list of reps that you get from the company on some of the tax-related matters. And unfortunately, one of the biggest challenges which I've seen in India really is that a large chunk of the reps that you've really got, that there are no tax litigations, there are no potential tax exposures, you end up in situations where where the portfolio company ends up with large tax bills. It can come in areas like transfer pricing. It can come in because of retrospective changes to law. That happened quite a few times in the past. But that becomes one key area of challenge. And really there, Webber's point on the diligence actually comes through, because really when it comes to tax-related reps that you're really getting from the company, you better have enough comfort upfront in terms of some of the positions which the company has really taken, rather than just relying on the blanket reps that they have really given. The second area where I've seen disputes is on tax indemnities. And I've seen both kinds of disputes. One, inter se the buyer and seller, and also inter se the tax, the buyer and the tax authorities on withholding tax obligations. I think as was pointed out in the previous panels, I think one of the key issues in India is that the buyer has to withhold tax at the time of purchase. So you really have a very heavily negotiated indemnity provision when it comes to withholding tax obligations, and with the buyer trying to pass on as much of the risk as possible to the seller in most situations. But there have been situations where, I've seen a live example where the parties had agreed to go and seek an advanced tax ruling. And based on it, they had estimated certain timeline as far as the indemnity was concerned, on the basis that advanced tax ruling ought to have been given in 6 months. Unfortunately, the advanced ruling took 3.5 years, where the tax authorities come in and say, well, we are not going to give a ruling on this particular aspect. So you're stuck in a sort of situation where the parties want to go in before the High Court, but there is obviously an indemnity which is lapsed or about to lapse. And there's an inter se dispute between the parties, and both parties are fighting as to whether we should go to the High Court and appeal, or does the indemnity come into effect. So that actually, so today when you're looking at an indemnity related provision, you actually need to provide for or envisage what are the situations which can potentially arise. And everything need not necessarily be a good case, especially for withholding taxes. The third interesting area is really Vyapak, what Vyapak was talking about when he spoke about, well, I've gone against the promoter, the court or the arbitrator has awarded a large chunk of damages. Well, is that the end of story? Not really. Even there's a lot of dispute that's currently happening. I think the prime example was in the Satyam case, where a bunch of investors had actually gotten entered into settlement agreements with the company. And there were certain payouts that were being made. And under the terms of the agreement, there were certain advanced tax rulings that had to be obtained in order to determine whether or not the amount that was paid was going to be taxable in India or not. The presumption that everyone went on was on the basis that since these are payment of damages or compensation, there should not be any tax consequence in India. But you had an advanced ruling that came out which said that, well, these are still Indian-sourced income because the company was situated in India and the company had actually undertaken the fraud. And you have to pay a 40% tax as far as the payment of damages are concerned. Obviously doesn't put someone in a great position. We are in fact arguing another case right now on the same issue, on the grounds that, well, it ought not to be taxable in India. But again, I think the bottom line there is that, well, even if you do manage to wring out a lot of money from the promoter, you still are subject to the tax authorities taking out a large chunk of it. I think that's briefly in terms of some of the different tax aspects that are there currently.
Yeah, I think
Vyapak. You want to look at the questions first before?
Question means
You want to
Yeah.
check for the questions first?
I thought that if you want to say anything, a very quick word on enforcement challenges, if at all.
Sure.
So, we close it in maybe less than 1 minute or two you can take.
So I think obviously what we talked about was more on the dispute resolution. Enforcement obviously would take back you to India, and there would be certain challenges when it comes to enforcement. But that again, India had a very bad experience when it came to not enforcing some of these foreign awards, because that was the first bilateral investment treaty claim which India lost for not enforcing an award against one of the public state enterprise which was obtained by a private company. The claim was purely based on the fact that in spite of the award, it sat in Indian courts for more than few years, and therefore the expectation or the issue of getting judicial support for any of such issues itself is violation of bilateral investment treaties, and India lost that claim. Post that, obviously things have improved when it comes to foreign awards, and therefore you need to also look at bilateral investment treaties when it comes to investments, because if US doesn't have a good bilateral investment treaty, then better you invest through a jurisdiction which has a good investment treaty, because in spite of the fact that you might have used that jurisdiction only for the purpose of as a special purpose vehicle or only for the investment purpose, but still you will be entitled to bilateral investment, and which can be a good form of enforcement than otherwise. So there are ways and means to look at it, and
Yeah, and I think just to add, interestingly enough, a lot of people do like using Mauritius for that reason.
Yeah.
Sure.
I think, thank you so much. We have some 10 minutes to close, and we would like to take any questions if we could not do that in the course of the day. But can we first ask people if they are on the phone, and I saw there are quite a few people on the phone, but if they want to ask a question, we'll give them first right, and then we'll address it here. Thank you.
Thank you very much, sir. Ladies and gentlemen, we will now begin the question and answer session. Anyone who wishes to ask a question may press star and 1 on your touchtone telephone. Participants are requested to use only handsets while asking a question. Anyone who has a question at this time may press star and 1. Please press star and 1 if you want to ask a question. Mr. Desai, we're going to take a first question from the audio. It's from the line of Mr. Madan Goyal from Seven Hill Group. Please go ahead, sir.
I had a question more not on the contents. It's been great listening in about the materials. If those people on the phone, is there a way for us to get the material?
Yeah, certainly we will be happy to mail them, and we are going to also telecast on our so-called television, Nishith.tv, the whole proceedings. We have our own web TV. Yes, actually, if you go to our knowledge site, what you call website, we call knowledge site. We'll be uploading all this on our TV. And today we have also launched what you call app. It's called Nishith Mobile. And on that, in 2 or 3 days' time, you'll be able to see each of the panel discussion. So we'll do everything that we can connect with you. And if you have any question, feel free to always ask. We are delighted that you've been part of this conference in a virtual fashion. But thank you so much. We'll do. Okay.
Thank you for putting on the conference.
Yeah, please send us your address. I do not know if you have to mail something. Then we'll, if your address is already there, then perfect. Because email copies also can be sent, but I'm sure you will enjoy the physical copies. Thank you. Any other question? Any other comment?
No, man.
Thank you.
Thank you. A reminder to all participants, please press star and 1 at this time to ask a question.
I think seems that
Mr. Desai, there are no more questions. from the
okay,
audience
fine.
line.
And I
Thank
think we have a gentleman here who has a question. Please now. Sorry for not being able to attend to your question earlier, but now you can have.
Oh, okay. It is not a question, it is a brief overview comment.
Oh, thank you.
This event is enormously important. The health overall of the Indian economy, over 1 billion people, is not only of importance
Yeah.
to India, but is of great importance to the increasingly interconnected economies of all the world. So what must be done, of course, is to bring your growth rate up to Chinese-style 7% or so. And it's doable with confidence brought about by Prime Minister Modi. It looks very promising. And my comment is mainly that, look, what is necessary is for the overseas financial banks and institutions to lend to India long term. And they have not only is this good business for them with the changes that seem to be coming, but it is in the self-interest of everybody. That is really all I wanted to say.
No, we really appreciate your input, and if anyone else has, this is the first time we are doing this program in New York, and in many ways our expectations were exceeded. Thank you all for that, because we thought there'll be 60, 80 people. We got registration about 150, and a lot more people are on the phone separately. So it was overwhelming response. We had to overnight change the hall from small room to the big room. So you can understand. So if there are any defects or anything else, that we would like to apologize for that. But do give us your suggestion on email or otherwise. But it has been wonderful. I'm sorry,
I did see
Vinita.
two other hands,
I didn't look at you. Please go ahead. And after this, we have a small cocktail because we have won the Financial Times Most Innovative Lawyers, award, and second most innovative law firm in Asia, including Australia. And I think Financial Times representative Reena Sen-Gupta is going to arrive for that purpose, just to celebrate with us. So please stay on. And Vinita.
Vyapak, this question is for
Thank you.
As you know, a lot of our clients want the foreign seated arbitration because they don't want interference of the Indian court. But at the same time, it's very important to maintain the right to get injunctive relief, because especially if you have contracts like IP contracts or confidential information and all, is there any way to kind of get that balance right? It's not necessary for all contracts, but
Sure.
for some, it's very important. So
Sure.
your thoughts on that would be helpful.
Yeah. So earlier this was very much possible, but unfortunately after the judgment, Balco judgment, it has completely ruled out that you can go to Indian courts for getting any interim injunctions if you have chosen a seat which is outside India. So that is at the moment completely not possible, unless, like in other jurisdictions, let's say even Singapore, they actually amended their law to bring in under Section 9, which is commonly known for any interim protection pending the arbitration, to even give powers to courts in Singapore to give such interim injunctions when the arbitrations are not seated in Singapore. Unless similar amendments come in, I don't think it is possible so far as India is concerned. But what we have seen in last 1 or 2 years is that most of these arbitral institutions have tried to address these issues by what they call is emergency arbitrators. So what they do is, irrespective of whether you have 2, 3, 5 arbitrator where other side has to respond in 30 days and all that, they actually appoint an arbitrator in 1 day, and that arbitrator is supposed to give an order within like 3 to 5 days or 7 days, depending upon a situation, for such interim protections. The only challenge to those interim protections sometimes is they may not be directly enforceable. But our experience, and I'm telling you from the perspective of obtaining such emergency protections, is in most of the cases, the other side would not want to not comply with such emergency protections. 2, based on those emergency protections, some of the jurisdictions, again like Singapore and London, they allow to go to court and turn into a judgment very quickly. So then those judgments get enforced in India very easily. Obviously that would take, let's say 1 week, 10 days, 15 days, and sometimes you want to injunct something which is perishable. In those situations, you are little at a disadvantage. But even in cases of bank guarantees, even in cases of freezing of bank accounts, the banks have actually taken cognizance of such emergency arbitrators' orders and freezed or didn't allow the bank guarantees to operate. So I think though this may not be legally most sound enforceable kind of an order, but you would be still better off to take seat outside India unless you are so inclined to go to Indian courts and get that interim injunction. So depending upon a situation, you might want to take a seat in India and choose an institution like CEC or LCIA to govern it. But otherwise, you are still better off, and we see those enforcements still happening.
Also, just to add one point, in some cases, you can take help of violation of any law as opposed to a dispute on a contract. Especially in IP, this may be a possibility.
So any other question or comment? Yes, please, most welcome. Thank you.
I had a question for Matt Nimitz. Matt, you made an assertion that the real business in India doesn't happen in meetings of boards of directors, but at family weddings and dinners. My question to you is, who do you suppose should represent your average shareholders at those dinners and family weddings? I've been to more than my share of Indian weddings, and frankly, I'm not that is not where I want to end up.
Yeah.
I would like to see more on the board of directors, and as one of the larger external investors in India, how do you suggest we go about, having not go around, disenfranchising your average shareholder?
Yeah. Well, I think it's an important point. I did mention going to weddings and family events. I didn't say that's where all the business took place, but I do think that sitting down with the promoter, sitting down with the other directors or key people, having conversations the day before the formal meeting, etc., are very, very important. By the way, I think that's also true in this country to some extent. Now, I will say something about board meetings. I think board meetings are important. Notes are taken, minutes are taken, and people should attend those meetings and should make the points. Hopefully, important issues are not rammed through at board meetings in any private companies, because I think that it's not an effective way of governance, especially if you have a majority and minority situation and you want consensus. What we've done at General Atlantic over many, many years is having veto rights, and that's sometimes at the shareholder level and sometimes at board level, depending on the jurisprudence of the particular place. I think in India it's probably more at the shareholder level. But to have reserved rights that need to be approved by shareholders and rights on appointments, rights on budgets, rights on borrowing money, other types of rights, and asserting those rights. But I think the dialogue in any company is the critical thing, and I think weddings is it was sort of a metaphor for maintaining good relationships with the other side. But I think it needs time to talk to the key people in the company.
Thank you. I think it's exactly 5:50. I think, thank you all. I think we kept up to the time on the dot. It's a precision clock here. And I think I'm very happy that we could discuss so much. I'm aware that it's not always easy to compress everything in this kind of conference. But we had several requests from other cities. So actually on 3rd of September, we are planning to have it in Hong Kong, because we were told that why don't you have this in Hong Kong? And on real estate investment trust, again, we had lots of requests. So in Singapore, with Apria and others, we are doing some event, I don't know the date, but we have been getting requests from so many places. Whatever little we can do, we are trying to do our best. Otherwise, we use technology. And we really thank you so much for this wonderful time that you spent with us. And I personally and all of us owe a lot to you for your cooperation and patience as well. And outside now we are going to have a small cocktail. Do get intoxicated a little bit. You had a lot of food served in terms of knowledge, hopefully. Also, this feel free to take this whole set of book. We have also provided a small bag, so you can carry along with you. And if you want any other thing, please let us know here. So, and thank you so much. It's a break. Thank you.